Hi there, this is Jonathan Ginsberg, and I want to talk to you today about my approach towards what I would call creative arguments. And what I mean by this, these are things, and I just made a short list. For example, if I have a case where there are earnings after the alleged onset date, or if my client is going to testify that he used marijuana to deal with nausea or pain when marijuana is not legal in the state. There's no medical marijuana laws, in other words. If my client used alcohol to self-medicate, that's another situation I come up against sometimes. Or I have a client who's doing activities that sort of seem like work. Maybe they're watching children, maybe they're taking care of pets, something like that, where it kind of looks like, well, maybe that could be work, but I've got an explanation as to why it wouldn't be. And so I call these creative arguments. These are things that would raise an eyebrow with the judge, but I want to deal with it ahead of time. So kind of what I do is, if I have a case like that, I'm always going to write a pre-hearing brief where I lay out my argument very clearly in writing. It's a lot easier to set it out in writing where you have control of exactly how you say things and your phraseology, as opposed to trying to do an opening statement on the fly. I think the second thing I like to do is I always ask the judge for a pre-hearing conference, meaning I try to go in ahead of time when there's nobody else there, just the judge, myself, and the vocational witness and hearing officer, but not the client, not my client. The reason I do that is that I want to be able to express myself a little more freely without the pressure of having my client there. And I'll flat out say to the judge, you know, I've got this argument here that's a little bit creative. I don't want to upset the court. I don't want it to insult you, make you think I'm asking for something ridiculous. But I want to try to get a sense of where you're leaning with this. So, for example, if you have a judge who is going to be completely against the idea of self-medication using alcohol or marijuana, find out about that ahead of time. That's not something that I want to know when my client's sitting there and I'm trying to make the argument when we're actually on the record. I do it off the record. So that way I know if I got a problem, I can go back outside, explain to my client, here's what we got to do. I just had a case, for example, recently where I was trying to make an argument that my client had worked for a year at a job, even though he was really not doing very much. His employer, as a humanitarian gesture, basically gave him a job and essentially paid him for just showing up and not really doing anything. I was trying to obviously argue that was not substantial activity and should not count against him. The judge said, well, was he actually physically at the location? Well, yeah, he was. Was he getting paid, you know, a decent hourly rate? Yeah. Well, the judge basically said, look, I understand your argument and I appreciate that, but I just cannot find this person disabled during a period of time when he was physically at the location getting paid and so forth. So I need you to consider amending your onset date. This was all done out of the presence of my client, just between the judge and me, much more relaxed. I was able to go outside, explain to my client what the issues were, and we didn't waste the judge's time. And I think the judge appreciated that. And again, it allowed me to get a feel for what the judge was really thinking. So that's what I try to do. And certainly when you're talking to your lawyer about how to present an argument, you know, your lawyer is going to be concerned about not creating a bad reputation with the judge, and your lawyer is going to want to make sure that he doesn't look like a fool on the record. So, you know, the good compromise is to sort of just, again, think outside the box a little bit, write a pre-hearing brief, setting out the argument, talk to the judge ahead of time, out of the presence of the claimant, and really just make the judge's life easy. That's ultimately what I try to do. So that's a little bit of insight of how I approach what I would call creative arguments in Social Security. And if that's useful to you, I hope that it certainly would be. And any questions or any ideas for additional videos, please let me know. Thanks a lot.